understand by the concept of characterization in determining what law to apply in a given conflict problem. Characterization, otherwise known as classification or qualification, is the process of assigning a certain set of facts or factual situation to its proper or correct legal category. Every rule of law is based on situations of facts, actual or imagined, since the legislator must try to solve factual situations that might arise in the future based on past observation and experience. These legal categories may be family relations, contracts, torts, succession, or property. By characterizing the legal problem, the court or the parties involved reach the proper solution whether to apply the local law or the proper foreign law. What makes the problem of characterization or classification difficult? The difficulty in characterization arises from the fact that a conflict's problem or situation may be characterized by the lex fori differently from the characterization of the lex causae, the law of the state with which the act or transaction is most closely connected. The lex fori might regard the problem as tort, while the lex causae regards it as contract, or the lex fori might regard the problem as crime, while the lex causae regards it as only tort. So which characterization should apply? Most writers hold that on the grounds of practical necessity and convenience, it is the forum or the lex fori that should determine the problem's characterization, unless the result would be a clear injustice. Let's take a look at Gibbs versus Government of Philippine Islands. A Californian wife dies. Her Californian husband claims the entire properties acquired by the spouses during their marriage as his alone by accretion, following California law on property relations of spouses. Under Philippine law, however, this is a problem in succession, so that inheritance taxes should be paid by the husband as the lands in question were located in the Philippines. The Supreme Court held that the properties inherited by the husband were subject to inheritance taxes, categorizing the problem as one of succession. Now suppose the problem of characterization involves a determination as to whether the matter pertains to substantive or to procedural law. How is the problem to be solved? There is no question that all procedural matters are governed by the lex fori. Thus, matters of service of summons, joinder or splitting of causes of action, how to appeal, or periods of appeal are governed by the law of the forum. But what about prescription of action and the statute of frauds? Are they substantive since our law considers them as such, so that they are found in the New Civil Code as well as the rules of court, or are they merely procedural and therefore governed by the lex fori? The modern trend is to consider the prescriptive periods or the statute of frauds that the parties had in mind at the time the transaction took place. For example, A, an Englishman borrowed money from B, another Englishman in England, evidenced by a promissory note. Let us assume that under English law, the period to sue on the promissory note is 4 years. In the Philippines, the period of prescription is 10 years. If action is filed in the Philippines beyond 4 years from the issuance of the note, but within 10 years, should we hold the action as prescribed? Answer: yes, because English law was evidently intended by the parties to govern their transaction.